I have already started the recording, and now let me pass the floor to Ms. Jennifer Gartlan, who will be our first speaker today.
Thank you so much for having me today. It is a pleasure to speak with you about the development of ADR in the US. It's grown exponentially over the past 20 years. And in speaking with my colleagues shortly before the webinar today, we were a little surprised to realize that the origins here have a lot of similarities to what you've seen in Poland. Back in the early 1990s, our legislature looked at what was going on in the US court system and were concerned about court backlog and the ability to expeditiously address cases. And so in 1990, our legislature introduced the Civil Justice Reform Act, and it required courts to explore the use of alternative dispute resolution to resolve case docketing. And the results were actually pretty good, and it led to further exploration on the court level. In 1998, for example, we had the ADR Act, which required US federal district courts and bankruptcy courts to implement rules for ADR. And this is an important feature because what Congress decided was to allow localities to address how mediation was going to be provided on a smaller scale. So each jurisdiction, each locality would have its own way and ability to develop things based on the needs and interests of that locality. And what also followed was US federal administrative agencies. So when you hear in the news, about regulatory issues, environmental issues that are going on in the US, there are a number of regulatory agencies that oversee them. And what Congress did in 1996 was pass the Administrative Dispute Resolution Act to require federal agencies to explore the use of ADR and to designate someone within each agency as what we call a dispute resolution specialist to advise on the use of ADR in those issues. And in my career, I have had the opportunity to help grow, develop ADR in both of those facets. And so from the US perspective, part of the flexibility has allowed for the growth that we're seeing. It's also really important because a lot of these US agencies and courts are dealing with international-based parties and multicultural issues. And let me give you an example. When I ran a program for the US Federal Maritime Commission several years ago, we were dealing with international shipping disputes. Some of the very supply chain issues that you hear about in the news in Poland today, we were seeing 10, 15, 20 years ago as well. And oftentimes we used mediation and facilitation and the use of organizational ombuds in real time in the pre-litigation phase to resolve those disputes. And one of the benefits of the way that Congress put together our legislation to allow the agency to create its own rules allowed us to have flexibility in the way we delivered our services. So for example, if we had a party that had a cultural orientation that needed a regimented solution. There are some mediation programs that are structured with a lot of rules, a lot of formality. There are other mediation programs that rely on, in certain cultures, that rely on a more informal narrative approach. And by having flexibility to design and implement and deliver services that took into account the needs from a cultural perspective, we were able to level a playing field so the parties could have a meaningful negotiation to allow them to air their differences, seek commercial resolution that took into account what they needed to do to get cargo moving efficiently and effectively to, in some cases, save the businesses for smaller entities that had cargo that was stuck in an international location that couldn't get out, or a cargo that had been transported to the US by a foreign corporation that they had difficulty with. And we're able to essentially take that difference of cultural orientation, bring them together in a meaningful way. Another element of this that we had flexibility in dealing with, and we see this in court as well, is power and differences that are brought about by language barriers and language differences. And in a lot of these negotiations and in these mediations, we used interpreters or staff members with multilingual capability to ensure that all parties were heard understood, and brought together to be able to look not only at the legal issues involved in the case from a regulatory perspective, but also really with an eye towards what commercially was driving those parties and what needed to happen to allow for a more holistic resolution. And it's this holistic resolution where we're looking at the commercial, we're looking at the legal, we're looking at, sometimes personal or cultural needs that need to be fulfilled, that have also made ADR very popular in the US court system, coupled with efficiencies and timing. And in talking about for example, the administrative aspect, one of the longest cases I had took about 9 months. It was a multi-party mediation. And when I compare what happened in that pre-litigation piece with the litigation in the US that can sometimes take upwards of 12 years or more, going back and forth between various stages of litigation, there's a lot of time savings there. And that's something that we really look to on the court aspect when we're looking to control our docket, to provide meaningful services that are holistic in nature. And so, for example, in DC and in a lot of American courts, we have programs that deal with mediation services, for example, at various stages in the dispute. So, for example, we have trial-based mediation services that work with parties either before American discovery occurs. And for those of you who may be familiar with American mediation, American litigation, discovery is a very intensive process of information exchange. And so by bringing parties in sometimes early in a dispute, it can save a lot of money and time for the parties. Sometimes they are brought in post-discovery, but before a decision, for purposes of getting additional information and being able to resolve the dispute in that stage. And as the program developed in the courts, you see subject matter specific mediation elements come about with different rules and techniques that are specific to that subject matter area. So for example, in DC, there is an entire probate division that deals with probate issues. There's a family law division where individuals are specially trained to handle those types of issues because there are certain nuances in that area of the law. There is a civil trial division where there are more complex litigation matters that are addressed through that aspect. In small claims, which maybe are less intensive and have a different set of rules and approach to make resolution of those types of cases more effective. What may be a little bit different than other jurisdictions and in other countries, such as Poland, is we also offer mediation at the appellate phase. So in other words, after a decision is made below, if a party appeals in our court, and in many other US courts, they have to provide what we call a mediation screening statement to determine whether appellate mediation can be used to resolve the case at that point in time. And from that perspective, we've seen a lot of success in terms of revisiting the use of mediation where it may have failed several times before at different stages, because the parties have gotten a better sense of the weaknesses, the risk involved, and and also at this time, by the time it gets to the appellate phase, they've been in litigation for some time. And so there's a timing element. If there's a commercial transaction, for example, sometimes there's a lien on a commercial property. They can't dispose of the property given the litigation, and there's a fresh look at ADR from that standpoint. And the program is flexible in the way it's put together so that we are able to not only address sometimes appellate litigation that comes in front of us, we're able to take cases from below that are related to that case and create global solutions for those particular cases in that particular time. And it's the flexibility coupled with our ability to work across various cultural considerations, across various approaches to mediation. For example, in our program, we're a little bit more evaluative. We look more at the merits of the litigation as a risk factor than some of the programs below that are exclusively what we call facilitative mediation, that really work to just help the parties communicate more effectively with each other. And by having the flexibility to design a program that meets the specific needs of the point in time that the mediation is occurring in the dispute, as well as the needs of the parties, and to develop services that are party-centric and individualistic to those parties, we've had significant success in being able to provide parties with solutions that oftentimes give them something that they would not be able to get if they had gone through and actually won their appeal. So from that perspective, we've gained a lot of traction in terms of interest in mediation, whether it's court-based, whether it's administrative-based. There are also a lot of private party providers of mediation. And in addition to the general success of it, we have noted that during COVID and with the introduction of online mediation services, that the demand, especially at the trial level, is greater than ever. And speaking across jurisdictions with other courts in the US, I chair a committee for ABA where court administrators across the country get together. And anecdotally, what everyone has said is that during COVID, they saw a greater increase of case resolution, greater case of putting matters forward for mediation because of substantial delays in the court dockets. And this was both on the private end, this was both on the court end, and the ability to adapt and go online has created greater efficiencies for providing services with parties that are internationally based. So, and we do a lot of that in the court. Sometimes they're parties in different jurisdictions that we bring in for mediation using the online services, where it used to be telephonic. So it's been a huge development. And it's a lot more effective post-COVID in terms of the improvements that were made during COVID through the online ability to work with folks and bring them in, plus the fact that it worked. And a lot of parties have been able to resolve their issues in a meaningful way. And it is something that is continuing to develop. And, you know, as I noted before, on the administrative end, it's not just conflict resolution anymore, it's really becoming conflict prevention. And we're seeing a lot of providers focused on looking at trends in terms of things they're seeing, whether it's an administrative agency, whether it's a private business, organizational ombuds are becoming very popular in the US right now as a mechanism to say, these are where disputes happened before. These are how we're looking at them and resolving them, but we're also taking lessons learned to implement for the future so that we're not seeing the same patterns repeat again. And so in a nutshell, we've had a lot of development over the past 20 years. You know, we started just as courts being mandated to look at these things, to developing new versioning programs that deal with disputes at various stages of litigation and administrative disputes, you know, even pre-filing in some cases of litigation and post-decisional. And along these lines, you know, we really look forward to hearing from our colleagues in Poland to look at some of the synergies there and to see how mediation is growing and developing there, and you know, to further the discussion. So thank you.
Thank you very much, Ms. Gartlan. It was a very inspiring presentation. Now I would like to see Polish perspective to the contrary. And at first, I would ask Ms. Joanna Wsołek to participate.
Hello, everyone. Well, when I was thinking about the subject of today's webinar, putting aside European, Polish, and US model of mediation or other ADR, my first reflection was, what do we think, what America symbolizes for us in Poland? And usually the association is democracy, individual freedom. And if you say this from the perspective of a post-Soviet country, then you understand that your mindset somehow is in the contrary of these values. So for a very long time, we suffer from lack of democracy and freedom. And what does it mean? The people didn't really have the feeling that they have real influence over their lives. And they have been used to some kind of authoritarian way of resolving problems. So if there is a conflict, then there is authorities that have the only authority to resolve the problem and to render the decision that will be executed. So starting point was that we really don't have much influence over our lives because everything is regulated. And then with the change of the system, step by step, people have started to take responsibility over their individual decisions and lives. And I think that introduction of mediation shows very well how we learn to take this responsibility. Idea of mediation, actually, if you take this before the court, but especially during the court procedure, is to give back the parties control over the case. And to give them the feeling that even though they are in court, they still can make decisions for themselves that will somehow shape the future relation. And this is something that we need to learn. And this is why I think that the development of mediation is so fast, but still much slower if you compare it with US. So the number of cases mediated successfully in Poland statistically are lower than in US. And the reason for it is that we still need to change the mindset and to recognize that we can take the responsibility over our lives and do not rely on someone else, in this case, the court, to make the decision and to regulate. Obviously, what Jennifer mentioned, the reason why mediation is so, let's say, favored by authorities and legislators is the fact that we, as well as probably everywhere, have the problem with judicial system. So everybody realizes that the courts are overwhelmed with the number of cases. This is especially true after COVID. And that's why, on one hand, there is this motivation both from judges and from the law authorities to push at least some of these cases out of the court, and mediation seems to be the perfect solution. But also the realization by the people that if they go to court, that means that they are not going to have the decision for the next year, 2 or maybe 3 years. And very often they don't want to wait so long, especially if you take into account then if you are not happy with the decision, someone will appeal. So you are going to court twice, actually. All of this means that people are, in my opinion, slowly but surely getting confidence that mediation actually works. Because mediation is based on the assumption that the contract or the agreement, mediation agreement in this case, that you will make with the other party you are in conflict with actually matters. So you need to believe that this contract is as good as the court order, or maybe better. And the mediator's job is to explain to the people that very often this agreement is better than the court decision. First, because you have the influence, what will be in this agreement. Secondly, because you have much better chance of implementation of this agreement, because the other party has agreed to it, and actually also had the influence over the contract content of the decision. So because the mediation is very much favored in the Polish law, and you can see this by the attitude of judges who are more and more starting the proceedings by speaking openly with the parties about why they didn't try the mediation. If you want to start a court case, in the first letter, you need to inform the court if you have tried mediation, and if not, why. So the lawyers are using the formula that we didn't try the mediation because we don't see prospects. Okay, and in the very beginning, it was easy. You put this form and nobody would care about mediation. Now I see that the judges are more and more pushing you. Why you don't see this prospect? Have you actually tried? Maybe you should try again. And this is true, especially in the family law cases. We see the development, and this is even more true with the newest changes in the European regulation, a so-called Brussels II, where the family cases actually should include mediation. Why so? I think that mediation has the objective to bring the conflicted parties back to the table. So they start to speak and work together. And this is very much a good thing in the business relation. We always say that the business wants to work together and not to lose time in the court. So bringing them back, this is a win-win. And I'm not going to discuss with this, that's true. But this is even more true in a family scenario, because in the business, you have a choice. You always can change your contractor. You can change suppliers and clients, whatever. In family, people are stuck together. So they cannot get out of the family, and they are going to live in this family after the court decision. So we have a very good interest in making this decision, which is the resolution of the conflict, actually sustainable in the sense that people feel that this is working for their personal situation. And we also need to make it, let's say, easy to change. If mediation brings people to discuss the situation and to reach an agreement, then also give them the freedom to change this agreement in future when the circumstances changes. Otherwise, the life always changes and there's plenty of surprises. Otherwise, if people do not speak to each other, they have to go to the court every time the situation changes. If they have this good experience of reaching an agreement that is actually complied with by the other party, I mean, especially in the case family law scenario, then they have the freedom to modify this agreement in the future, which means they are not going back to the court every time something changes. And to the end, I would like to say that the law is always a little bit behind, in my opinion, and in the mediation market, there is a lot of ideas and ways of dealing with cases that is brought by the people who do the mediation, all kinds of associations, centers, workshops, and so on. And they are building models that actually are introduced slowly to the practice of the court. And I would like shortly just speak about one model, which is also based on the family law, in very specific case, which is the child abduction. This by nature is a cross-border case because it involves child being removed wrongfully from one country to another, which means that we need to have a decision of agreement that will be somehow workable in at least two jurisdictions, where the child is right now and where the child was taken from, or where the child is going to be moved. And this is one of the very good things about the mediation, is that contrary to the court decision, which is very difficult to be recognized and implemented in a different jurisdiction, mediation agreement is much easier to be just recognized by the parties who are not in conflict anymore. There is another aspect of the mediation in this kind of cases. We don't have time. We don't have the luxury of spending so much time, because the term to deal with the case with the child abduction is 6 weeks. For the court practice, 6 weeks is a very short period to deal with the case, hear the parties, sometimes hear the child, and to make the decision in the first instance. And there is an association of the mediators who are specialized in the child abduction, who have developed a model in which the court is inviting the parties to the mediation in the very beginning of this procedure, setting the court day like in 2 weeks from now. And the parents are giving the information that they have this 2 weeks, no more, no less, 2 weeks to find a settlement. Otherwise, the court is going to make the decision. And the pressure of the time, actually, with the danger of losing the case, which is a serious case, because the child abduction involves sometimes changing the life, moving from one country to another, a lot of decisions is involved, not only the case, but sometimes work, school, a lot of aspects that should be taken into account. And the people under the pressure of the time and not knowing what will happen during the 6 weeks where the court has to render a decision, very often use the mediation in the way which is very constructive, because mediation allows you to put in one agreement a lot of different decisions that normally would require a lot of different legal proceedings. And as we know, the court is very slow in making decisions, especially in transborder scenario. So you never know what are those decisions that you expect to have in future. In mediation settlement, you can include all of this together and have something like a package that is going to organize the future of your child for the future. So I think this is, for the moment, what I wanted to say about mediation in Poland, and probably it's going to be more and more interesting in the future. Thank you
very much. Thank you very much, Ms. Wsołek, for your presentation. And now I would like to ask Mr. Michał Araszkiewicz to conclude this webinar with his third and last presentation today.
Thank you very much. So thanks again for having me. It's a great pleasure to have an opportunity to participate in this fascinating seminar. A lot of interesting topics have been raised by my colleagues, and I believe that each of these topics calls for a broader elaboration. So I will try to be brief, and I will try to introduce here my threefold experience with alternative dispute resolution. The first perspective is the perspective of the teacher. I have the opportunity to teach the history of alternative dispute resolution and argumentation for alternative dispute resolution here at the Jagiellonian University. It's a good occasion to touch some American threads here, because teaching the history of ADR made me aware of the scope and breadth of the American contribution to the development of this form. Of course, I was listening with interest to the speech of Jennifer's and about the 1990s reform. In our course, we begin it at the outset, at the inception of the United States of the political organism. So the United States have become actually a kind of laboratory of environment where very different forms of dispute resolution have been tested. What is also very specific for American legal culture, like from my outlook, is that these forms have been developed in reaction to practical needs. It's a different perspective to the traditional continental perspective. So in the continental European tradition of law, typically we think about the law in terms of top-down regulation, that we begin with a very general statutes, typically all-encompassing ones, preferably exhaustive, preferably consistent. And then we think about how these general concepts are going to be specified in the judicial application. That's the first important facet. The second important aspect is that the continental law, by and large, is very formalistic in the sense that a small formal error on the side of an attorney or the court, for that matter, may have very severe consequences even before the substance of the dispute is subject to a discussion. American legal culture has been influenced very strongly by the philosophy of legal realism and sociological jurisprudence, the work of Roscoe Pound, Oliver Wendell Holmes, and others. These instruments, so the philosophy that accompanies the development of these instruments is different. Also because, like Joanna rightly said, the citizens have been thought of having some liberties by design in this political system, and is something which in Poland we began to relearn since 1990. That would be the so I think that there is still a lot of space for the transfer of knowledge and solutions and approaches, taking of course into account the differences of legal cultures, because not everything may be implemented automatically or one-to-one, copy and paste. Typically it doesn't work. We need to take into account the specificities, the peculiarities of the local legal culture, but fortunately something has started to change. So 7 years ago we concluded a huge national project about what are the main obstacles to the introduction of mediation in the Polish legal system, the broader introduction of mediation in the Polish legal system. And back then, 7 years ago, the main results of this research was that the most important obstacles are psychological or cultural ones, that there are trust issues, that people, by and large, they don't see sense in the mediation, that very often, if they consider submitting a case to a court or consult a lawyer in the first place, the conflict has already escalated to the extent that the parties cannot take into account seriously the possibility of an agreement. Thankfully, I have an impression that these phenomena have been subject to change. There are many factors that influence that. The duration and the costs that are associated with the litigation processes are of course very important factors. Unfortunately, we have not been very successful in dealing with these problems here in Poland. To the contrary, one may observe that during the recent years, the duration of many types of litigation processes are getting longer and longer. This may be also a very important factor that fosters the application of alternative dispute resolution methods. So that would be the outlook of a teacher. Now, moving on to the perspective of a legal practitioner. So I happen to be a transaction lawyer. As an attorney, I mainly negotiate contracts. Most of my time in my legal practice, I devote to negotiating business contracts. Business law is, of course, a different context than family law. At least most of the people, and of course not always, but often, for most time, they are institutionally constrained to be economically rational, which makes some things more effective, easier in the process of negotiations. But there are also different perils to this problem, namely that typically corporate entities, they have a really good outlook into the possibilities of winning the case in a court. They can invest money in the litigation process. Sometimes they intend to initiate a strategic litigation, which perhaps it is also something which takes place in the context of family disputes, but I believe that it's more common in business. But to my experience, for most of the time, business people are extremely interested not only in pre-trial conflict resolution, but first and foremost in conflict prevention. So good negotiation of a contract, really learning about the values, the goals, the principles that are important for these people, is the key to success. And here, again, let us make the reference to a classic American work. Harvard model of negotiations comes in handy. Of course, it has been subject to numerous developments in literature and practice during the last almost 40 years now. But this approach is still extremely useful. Moreover, what I particularly appreciate about negotiations is that they involve this broader context. So you have to take the formalities of law into account, but your knowledge of the economic circumstances, psychology, the argumentative patterns that you use, the language that you choose is less constrained than a classical litigation process. There are different constraints, but these are typical business constraints. And once you master the communication with business people, which, by the way, I think should be taught more extensively to the students of law and attorney trainees. So once you master this type of communication, it makes things easier, and it also makes the language of contracts easier to understand, also for the parties. Like avoiding these stereotypical legalese is very often important for the parties, and it is another factor that helps preventing unnecessary disputes. Of course, a contract non-performance may also happen, and then it's important to have good contractual clauses in a contract. How to handle this? Still, very often in contracts, there is also this small clause that the parties will attempt to solve the problem amicably, like in 30 days or in other deadline. It's very useful to have a more extensive clause dealing with this matter. And of course, there are a lot of problems that could be discussed here in more depth. And the third perspective I would be happy to invoke is the perspective of the rise of artificial intelligence technologies in the field of dispute resolution. So this disruptive technology has started to influence dispute resolution processes and the legal environment in general in many respects. So I'm happy to have been doing research on these topics for more than 10 years now, so it gives you a nice outlook, but the things are also changing on a very dynamic pace recently, so it's a very fast-growing economy and the context. So here I would like to invoke two issues. So first is that artificial intelligence technologies, data mining technologies, they actually foster information retrieval processes on the side of lawyers. So it's already possible to predict the potential verdict of the court with a considerable accuracy, which of course informs the lawyers about the likelihood of success in the court. And let us stop here for a moment, because this is actually tremendously important information, and it's brought to you by a provider of this artificial intelligence algorithm, which mines a particular data set. There are a lot of interesting questions which arise in connection with that. So how you as a lawyer should and can verify the prediction that is brought to you by this algorithm. especially if the algorithm itself is non-transparent and it can't be made entirely transparent simply because the way it operates is too complex for a human mind. So I will stop here because this is of course a very huge topic. And the last point is the use again potentially very fruitful and potentially dangerous use of artificial intelligence technologies in the context of online dispute resolution. So we already have computer programs that assist lawyers in generating the agreement, in finding an agreement, in showing how far we are from the zone of possible agreement. This is, of course, very useful, again, provided that the standards of training of this algorithm, the data set on which it was trained, is trustworthy. So this is a huge topic nowadays, also in Europe, in connection with the works on the Artificial Intelligence Act proposal. And there are also solutions that may, for instance, analyze your facial expressions or the tone of your voice and provide the user with the information on whether the speaker is trustworthy, so whether they are nervous or whether they are speaking sincerely. I believe that this particular type of technology is potentially very dangerous because it may bring some misleading information and potentially cause serious problems in seeking potential agreement between the parties. Thank you very much.
Yeah, thank you very much, Mr. Araszkiewicz. We are very grateful for your presentation, and now we are very happy to pass the floor to our participants. Do you have any questions? Also, speakers may ask questions to one another. I would most gladly receive them on chat. Then I will pass them to the speakers. So, would you like to ask about anything, or any clarifications, maybe further discussions? Maybe do you have, that's the question of the speakers, maybe do you have some follow-ups to, yeah, I see Mr. Araszkiewicz has a question. Certainly.
Yes, so I'm happy to have a question to both Jennifer and Joanna. So I might begin with a question to Jennifer. So this, because you mentioned the widespread use of online solutions in connection with dispute resolution processes. So I'd be grateful for like your comment, your perspective on that. So in which scopes or domains it worked well in your experience, what needs like further development, and according to your knowledge, what is the general approach of American lawyers, the judiciary towards the use of such technology? And can I also ask the question to Joanna now briefly? Because I have become very interested in this context of child abduction cases. I have no experience with that, but it made me like very interested because intuitively these are cases which involved a lot of emotion and very escalated conflicts, and so to my mind it's like the first type of case which like actually requires law enforcement. Like this is not the type of case particularly fit for amicable dispute resolution, but it would be extremely interesting to learn about how you actually begin to use it, like to bring the parties to discuss and finally find an agreement if the conflict escalated so much in the first place. Thank you very much.
Michał, so to answer your question, online dispute resolution is a very broad term. And so, for example, in New York, they're working on, and let me take a step back, just for the students who may or may not be familiar with the scope and breadth of it. You know, online dispute resolution can be anything from your eBay disputes, your PayPal disputes, things of that nature where you're typing in and having kind of an email dispute, to platforms that are created in jurisdictions. For example, New York has a pilot program that they've been doing with, and I cannot remember which program they're using, but a program where they're using whatever program they've implemented, where essentially a party goes in, types, you know, their aspect of things, and then a mediator is responding, you know, in terms of writing back. In our program and in our program in the trial court below here, and a lot of the courts that I've been working with in ABA, we've been using Zoom, particularly on my program, just because we want that video component to be able to work with parties and have those sessions based on the subject matter we're dealing with on the appellate level. The trial courts below here in their program initially started with WebEx. And there were some real challenges in terms of using WebEx because of lack of caucusing potential, that kind of thing. There had also been some programs that had talked about Microsoft Teams at one point, and that's problematic because of some transcript issues for confidentiality. But in our program, because we're at the appellate level, because we're trying to bring people together for a face-to-face session, so to speak, just based on where we are in the dispute resolution design at the appellate level, we're using Zoom. You know, it's either Zoom or in person at this point in time, and we have found it to be very effective. And anecdotally, I had heard a report from the Department of Justice that the Zoom mediations that they were using, I guess, for employment cases that they were handling, they were actually having a higher disposition rate in terms of settlement than in person. So it's been effective, it's been working. The long answer, though, is that there are a number of different programs that folks can use and different ways of going about it. So that's in a nutshell what works for us, but what's being used by others too.
Thank you.
Okay, if I am to elaborate a little bit about the child abduction. So the mediation model I was referring to is elaborated by the MIC association. MIC, this is the Center for Mediation that specializes specifically in international child abduction. So they are doing mediation in more than 30 countries, which means that they encompasses the cultural differences, linguistic differences. The model basically is that usually family is husband and wife, so man and woman in this traditional picture. So mediation is done by two mediators, a woman and a man. Usually this mediation has a transborder element, and usually it is also connected to different nationalities. So they try to have mediator from two different countries to somehow give the context about language, but also cultural differences, cultural values that are specific to the country where one of the parents come from, or to the country where they moved the child and they want to live for some reason. So this shows you how they work in the sense of overcome this transborder problems. When it comes to the emotional issue in these cases, child abduction is regulated by the Hague Convention, which is very strict about the deadlines. You have 1 year to bring the case if the child was wrongfully removed from the what we call the residence. And now some people start the cases in the very beginning. So you have the situation when the proceeding starts just after removing the child. Some cases start a year after, which means that the child lived in this new country for almost a year. And the life of both of the parents who are involved somehow changed. And that means that the initial ask for the return after a period of time sometimes evolves. Sometimes the case is only about establishing if the child was removed illegally and if there are any obstacles for the return. But oftentimes, what is the subject of international mediation are the condition of the return, which mean where the child is going to live, with which of the parents, what will be the visitation plan, to which school the child will be enrolled, what language will be learned to this language, to this child, what will be the relation with other members of the families, which oftentimes are very important in the family context. And so those are the things that people are discussing in order to somehow adjust or readjust the situation of the child, taking into account that one of the parents obviously was very unhappy, and this is why they have made the decision of going abroad, and taking into account that the child has identity which can be connected to one or more countries, one or more nationalities, languages, and so on. So the people, when they are during these Hague proceedings, they know that decision is going to be made. The court cannot leave this case open. So either the child is staying or is going back. And in both situations, there is plenty of questions which are not answered by the simple decision, child stay, child go. And mediation offers the parents this comfort of actually discussing the two scenarios. What will happen if the child stays? What will happen if I return with the child? What is the best interest of us as parents and the child? And then to make the decision which is somehow informed, how we want to continue. If they are able to make this decision, then the case is resolved because the court doesn't have to order the return or allow to stay, and the parents know how to proceed.
Thank you.
Thank you very much for those questions and answers. Are there any other questions? Oh, I can see something on the chat. But it was not about the question. So I think we can stop the recording part, and then we'll maybe the non-recording part of the webinar will give more courage to the participants to ask you questions directly.